That's why I try not to refer to myself as a divorce attorney. It was so prominent in the 70s and the 80s when divorce law was really ramping up. It was a lot of animosity. Divorce, divorce, divorce. Now, to be honest with you, probably a third of my cases are unmarried couples. So what issues do I have with that? Custody and child support. But like you said, consequences of marriage, talking about divorce now, talking about spousal support, interim and final, and the big ticket, community property. You know, and some people's community property is relatively straightforward. Okay, everything they bought, everything they had was during the marriage. A house, retirement account for dad, at a 401k and an oil and gas company. Mom was a teacher. She has, school teacher's retirement, things like that.
There's some offset there.
Yeah, there's some offset there, absolutely. Normally, people that have a fair amount of assets, it could be relatively easy because you're moving pieces around.
Yeah.
If I get another attorney and there's a dozen, 15 other attorneys in town, I know when I get this case, if they're on the other side, we'll be able to settle the community property because the facts are there. Clear, straightforward. Even if we can't settle it all, we're only going to litigate an issue or two. Saves money for the client, saves stress for me and the client. Happy client, they tell other people about me.
That's why you're such a good referral. That's why I like sending people to you, because I know that you sit down and you're very honest with your client and say, look, this is going to cost a lot of money, right? And this could get really ugly, but let's try to work and play nice on some of these deals. If we have to get ugly, we will get ugly because that's where it's going, but that's not the best route. No. I don't need to make a ton of money on your case. I want you happy because I want you to send me people in the future.
Correct. Right. I'd rather have, 10 $5,000 cases with happy people, less stress going out the door, than one $50,000 case.
Right. It's 10 closed cases.
Right. 10 closed cases. And people don't want this to go on for forever, even though they might come into my office thinking, we're going to do this, we're going to do that, scorched earth. No, you don't. You might think you want that now, but that's not really what you want. And you're right. I don't bullshit. I don't sugarcoat. You're screwed on this. You have a good chance on that. I don't know on that. People ask me percentages all the time. Flip a coin.
Right.
Because there's stuff that's going to come out. Because people are, unfortunately, always honest with their attorney. I find out things in the back end. Well, you could have told me this early on. You filled out this questionnaire. I asked you this at the consult, and a month later, you didn't tell me. So don't hide things from me. On the other hand, you have people that are doing great, and they hit a snag somewhere in a new relationship while litigation's going on, and it'll sink their case.
Life happens.
Life happens. Absolutely.
Yeah, I tell everyone, be honest with your attorney. You have the highest level of protection for the communications you have with your attorney. It's confidential. It's privileged. Why would you not tell your lawyer? And that's the same in personal injury as it is in family law. Right. I want to know where all the bodies are buried, right? Because then there will be no surprises. The less amount of surprises I have, the better representation I can give.
Absolutely.
So this is the beauty of law have mercy. You're talking about these community property, excuse me. And I'm on mylouisianasuccession.com and seeing what is Louisiana under Louisiana law, what is not considered community property, and there's some legalese going on here. I'm hoping that you can break this down for me. So it says right here in the second bullet, assets acquired by a spouse with separate property or with a mix of community and separate property when the value of the community property used to acquire the asset is inconsequential in comparison with the value of the separate property used. Can you please break that down for me?
So if it's a minimal cost coming out from separate property to community, this literally kind of makes it easy for the court to more or less just say, look, we're going to lump it in. We're going to count it as X or Y so you don't have to fight about it.
Yeah.
And that's, little things putting down, well, yeah, that was my car, but you added the $2,000, this, that, and the other to it. So is it, community funds being used to enhance my separate property? Look, if it's inconsequential sometimes, you don't count it. And likewise, I know you said that you pull it from a succession site. Something else that people worry about, what about my inheritance? When you get that inheritance, it is definitely your separate property 9 times out of 10. But you have to be careful what you use it on, what those fruits and what the growth on that inheritance does. Okay, your parents gifted you with this retirement account that they socked money away in for 20 years without you knowing. Well, what about that now? What are those funds now? Sure, the base value when you were married is absolutely your separate property. But if you didn't reserve certain fruits and revenues and they were done through no hard work or labor of your action, that could be community value.
Yeah, that's another great word from family law is commingling, right? And so if you inherit money, it's separate property. Now, if you take it and you put it into the joint account, the community account, and it gets, you take out 500, you put 1,000, you take out 2,000, you put 500, and it starts getting commingled, and we can't readily identify it from looking at a few bank statements, then you pretty much lost your right to that separate property.
Yes and no.
I knew you were going to say yes.
The one word.
Such a good lawyer.
The one word you didn't add to commingling was hopelessly commingled. That's the phrase where you see in court cases where it was such a nightmare that the court would throw their hands up. You'd have 2 CPAs, 2 attorneys, sometimes a third CPA, everybody arguing for it. Each party has their own expert. The court may have their own expert to try to figure it out. That was very prevalent, like we said, when in the 80s when divorce really ramped up, community property, custody was just nasty. Things like that. You can't figure out where the money went. Now, with the advent of electronic banking and records being held longer, and a judge who's willing to do the work. And one of my favorite judges here, locally in the 15th JDC, said, look, it's not that really hopelessly commingled anymore. If I can get the records, I'll figure it out, or the attorney should be able to figure it out for me. So that's why I say yes and no. A lot of it depends on records. How far back can you go? The IRS, and again, whoever you have for your tax podcast can probably answer this better than me. IRS only has to keep your returns for so many years. If you're dealing with a 30-year marriage, forget about divorce documents for divorce from 25, 30 years ago. But recently I have had a case where I had to go back 17 years. Tax records were gone. Bank records, forget about it. They were gone at the 3 or 7 year mark. How did we get financial details? Social Security benefits. So all the quarters, everything they put in, Social Security kept that better than the tax records to figure out what that person was grossing and or netting. Some minimal details, but details nonetheless for the income for those years. That was 20 years before.
So if you're listening to this and you get some separate property from an inheritance or some type of other form of separate property, keep it in a separate bank account, because then you don't have to pay for 2 or 3 lawyers. You don't have to pay all competing CPAs. You don't have to ask the judge to go through spreadsheets for the last 10 years. Keep it separate and don't hopelessly commingle it in the bank account.
And